This module will enable us to understand the nature of check as a negotiable instrument, the basic work done by a banker, the meaning and various types of crossing of a check, and Section 138, which lays down the important rules on the bouncing of a check becoming a punishable offense.
A check is a negotiable instrument in the form of a bill of exchange drawn always on a banker. The banker has an obligation to honor the check unless there are valid reasons to dishonor it. A banker issues blank checks to its customers who have deposited amount with them. Whenever the customer wishes to make use of the money lying in his bank account, he issues an order to the bank through the check to release the stated amount of money in favor of the specified person. This check becomes an order to the bank in the form of a bill of exchange. The drawer of such a bill is the account holder. The drawee is the bank and the payee is the person made entitled to obtain this payment.
Before understanding the mechanism of the crossing of checks, let us first go through the basic terms. We shall begin by studying about checks. A check is a negotiable instrument in the form of a bill of exchange, always drawn on a banker. A banker issues blank checks to the customers who have deposit accounts with them. Whenever the customer wishes to make use of the money in the bank account, they issue an order to the bank through the check to release the stated amount of money in favor of the specified person. Who is a banker? A banker is an institution or an individual engaged in the banking business. As per Section 5B of the Banking Regulation Act 1949, the term banking has been defined as accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, and withdrawable by check, draft, order, or otherwise.
This act has described a banking company as a company which is doing the business of banking in India. The primary activity of a banking company would be accepting of deposits for the purpose of lending or investing the same. If the purpose of accepting of a deposit is not to further or lend or invest them, for example, where a company accepts public deposits merely for the purpose of financing its own business, the business would not be called as a banking business. Another notable feature of banking business is that the money deposited should be repayable to the depositor on demand or according to the agreement. The demand should be made through an order, a check or a draft, or otherwise, and not merely by verbal orders. A person who maintains an account in a bank is considered to be a customer of the bank. But to be a customer of the bank in a real sense, there must be interactions between the bank and the customer involving business of banking, for example, depositing and withdrawing money or taking loans. Merely making use of the services provided by the banker, such as encashing of a check, transferring of money through a bank draft, or maintaining a locker in the bank would not create a relationship of a banker and the customer.
Let us now move on to the meaning and effects of crossing. A check is said to be crossed when two parallel transverse lines with or without any words written inside, are drawn on the face of the check, generally on the left-hand top corner of the check. Crossing of the check changes its mode of payment only. It becomes payable into the account of the holder and not at the counter.
Ordinarily, the bank makes cash payment on the check drawn upon it as its public counter itself. The mode of payment is very common method to recover money on a check. However, it entails some risks too. A wrong person may somehow take possession of the check and obtain the payment at the cash counter. A solution to this problem is the crossing of the check. In this context, it may be stated that checks may be of two types. 1. Open or uncrossed checks, and 2. Cross checks. An open check is payable as mentioned above at the counter of the drawee bank on the presentation of the check. Payment on a cross check is recoverable only when it is demanded through another bank and not directly at the counter of the bank. The payee or holder of the cross check deposits the check with his own bank, and this bank collects the amount on the check from the drawee bank and deposits the amount in the account maintained by the holder. Thus, the chances of a check falling into wrong hands are removed as the person who ultimately recovers the payment on the check becomes traceable easily. This way, crossing affords security and protection to the holder of the check. A check is said to be crossed when two parallel transverse lines with or without any words inside are drawn on the face of the check, generally on the left hand top corner of the check. Crossing of the check changes its mode of payment only. It becomes payable into the account of the holder and not at the counter. It does not, however, adversely affect its negotiability. A cross check remains negotiable in the same way as an uncrossed or open one. For example, it can be negotiated by mere delivery if it is payable to the bearer, and by endorsement and delivery if it is payable to order. If the holder of a cross check keeps no account in any bank, he would have to open an account with some banker and deposit the check in that account so that the banker collects its payment on his behalf from the drawee banker and credits the same into his account. Another way would be that he may endorse the check in favor of a known person who keeps an account in any bank and allows him to collect the amount in his own account in the bank and then recovers cash from him.
There are four types of crossing. These are general crossing, special crossing, not negotiable crossing, account payee or restrictive crossing. We shall discuss these in detail. The first is general crossing, where a check bears across its face, generally on the top left corner, two parallel transverse lines without any words, or with such words as and company or and co, not negotiable, written in between the parallel lines. It is called general crossing. The second is special crossing. As per Section 124 of the Negotiable Instrument Act, where a check bears across its face the name of a banker, that additional name of a bank itself, without any parallel lines, shall be deemed to be a crossing, and the check shall be deemed to be crossed to that banker. The name of the banker may be put within the parallel lines as well. Such crossing would be the special crossing. This provides additional protection. The next type is not negotiable crossing. As per section 130, a person taking a check crossed generally or specially bearing the words not negotiable shall not have and shall not be capable of giving a title better than that which the person from whom he took it had. The object of not negotiable crossing is clearly to afford extra protection to the holder or drawer of a check. The last type is account payee or restrictive crossing. Such crossing can be made in the case of both the general as well as special crossing by putting in between the parallel lines some restrictive words. The implication of account payee crossing is that it is an order to the collecting banker to credit the amount of the check to the account of the payee or of the particular name only and nobody else. The liability of the collecting banker is increased in the case of a check carrying account payee only crossing. In case the proceeds get credited to any person other than the payee and the last endorsement in favor of the payee is proved forged, the banker will be held guilty of negligence and will not be entitled to the protection given under section 131.
Let us discuss the types of crossing in detail. Number 1. General crossing, where a check bears across its face, generally on the left hand top corner, two parallel transverse lines without any words or with such words as and company or and company, not negotiable, written in between the parallel lines. It is called general crossing as given under section 123 of the Negotiable Instruments Act. General crossing reflects the simple meaning of crossing as explained earlier. The holder may deposit his check with any bank of his choice and collect his money through that bank. The word and company will mean nothing at all, but the words not negotiable will reduce the negotiability as shall be explained later. 2. Special crossing, where a check bears across its face the name of a banker, that additional name of a bank itself without any parallel lines shall be deemed to be crossing and check shall be deemed to be crossed to that bank as given under section 124 of the Negotiable Instruments Act, or the name of the banker may be put within the parallel lines. Such crossing would be special crossing. This special thing in this is the mention of the name of special bank which alone could be collecting banker for this check. Where a check is crossed specially, the banker on whom it is drawn shall not pay it otherwise than to the banker to whom it is crossed or his agent for collection as stated under section 126 of the Act. Thus, in case of special crossing, the paying banker has to pay on the check only when it is presented through the banker specially mentioned in this crossing. Of course, the collecting banker can always act through an agent bank. Sometimes, a check may be specially crossed to more than one bank as given under section 127, which does not allow this. It requires that if the second bank has to be mentioned, it must be as the agent of the first bank. According to section 127, where a check is crossed specially to more than one banker, except when that bank to whom it has been specially crossed makes another special crossing in the name of another banker for the purpose of collection, the banker on whom it is drawn shall refuse payment thereof. A special crossing introduces greater safety than a general crossing because it would become more difficult for a wrong person to collect payment on such a check. 3. Not negotiable crossing. As stated earlier, the word Not negotiable may also be written in both types of crossings, general and special, as stated under sections 123 and 124 of the Act. A crossing on a check with these words is termed as not negotiable crossing, and it will restrict the negotiability to some extent. Section 130 of the Act states the effect of such a crossing in the following words. A person taking a check crossed generally or specifically, bearing in either case the words not negotiable, shall not have and shall not be capable of giving a better title to the check than which the person from whom he took had. Thus, the effect of such crossing is that it deprives the check of the essential characteristic of a negotiable instrument. So, no one can become a holder in due course of such a check. Although the instrument remains transferable, its essential negotiability stands diluted by this type of crossing. The object of not negotiable crossing is clearly to afford extra protection to the holder or drawer of a check. Even if a check goes into wrong hands and from there it is transferred to a holder in due course, the true owner will not lose his rights against such an endorsee. Thus, such a cross check must be accepted with extra caution about the antecedents of the endorser. 4. Account payee or restrictive crossing. Another way to give additional protection to the payee of a check is the practice of restrictive crossing. This is commonly known as account payee only crossing. Such crossing can be made in case of both general as well as special crossing by putting in between the parallel lines some restrictive words. Examples: account payee only or Ramnath's account only. The implication of account payee crossing is that it is an order to the collecting banker to credit the amount of the check to the account of the payee or of the particular name only and nobody else. This does not mean that an account payee cross check is deprived of its negotiability, although the ultimate receiver of the money on this check would be the payee. Still, such a check remains transferable, at least technically. The check may be put in circulation and the people may be ready to accept the check because of the goodwill of the parties. The final holder may seek the help of the payee in recovering his money by handing the check over to him, or may recover his money from his transferor or earlier parties to the check. The liability of collecting banker is increased in case of the check carrying account payee crossing. In the case the proceeds get credited to any person other than the payee and the last endorsement in favor of the payee is proved forged, the banker will be held guilty of negligence and will not be entitled to the protection given under section 131, where a banker acting bona fide will not be liable to the true owner if he receives payment of a cross check for a customer whose title is defective. Thus, the collecting banker must act very carefully and make proper inquiries as to whether the last endorsement is genuine or not.
Crossing is an important feature of the check, but not everyone has the authority to do so. The drawer of a check may cross it generally or specially at the time of issue, or may not cross it at all. Section 125 permits the crossing being made even after issue of a check in the following ways. Where a check is uncrossed, the holder may cross it generally or specially. Where a check is crossed generally, the holder may cross it specially. Where a check is crossed Generally or specially, the holder may add the words not negotiable. Where a check is crossed specially, the banker to whom it is crossed may again cross it, especially to another banker, as his agent for collection. Moving on, we will now study about the bouncing of checks. A check is said to be bounced or dishonored by non payment when the drawee bank of the check refuses payment upon being duly required to pay the same. Unless there are valid reasons to dishonor a check, the bankers must take utmost care to see that the checks drawn by their customers are duly paid when presented. Next is section 138, which is about punishment to drawer for bouncing of a check. A major amendment was the insertion of a new chapter, Chapter 17, in the Act, whose heading is Penalties in Case of Dishonor of Certain Checks for Insufficiency of Funds in the Accounts. This chapter contained five sections, sections 138 to 142. Since then, more changes have been made in the provisions of this chapter, including an addition of five new sections from 143 to 147. According to section 138, the drawer of the check shall be deemed to commit a punishable offense, and the punishment for the same shall be imprisonment for a term which may extend to 2 years, or a fine which may extend to twice the amount of the check, or both of these. However, the punishment enforceable under Section 138 shall be invoked subject to the following requirements. The check must have been drawn for payment of money to a person for the full or partial discharge of any legally enforceable debt or liability. It must have been presented to the drawee bank within 6 months from the date on which it is drawn, or within the period of its validity, whichever is earlier. It must have been returned unpaid by the drawee bank, either because of insufficiency of funds in the drawer's account or because the check exceeds the amount arranged to be paid from that account by an agreement made with the bank. Lastly, we shall discuss the procedure that is applicable under Section 138 in case of dishonor of a check. Within 30 days of the receipt of information from the bank about dishonor of the check, the payee should make a written demand for the payment represented by the check. If the drawer fails to make the payment within 15 days of the receipt of the demand notice, a written complaint should be made to a metropolitan magistrate or a first class judicial magistrate by the payee or holder in due course of the check within 1 month of the date on which the cause of action is under Section 138. There shall be a system of summary trial of such offences under Section 143 to speed up the disposal of the cases. The offences under this chapter shall be compoundable, that is, comprisable. If the person committing an offence under the aforesaid mentioned provisions is a company, every person who was in charge of and is responsible to the company for the conduct of the business of the company as well as the company itself shall be deemed to be guilty of offence. Let us recapitulate what we have learned in this module. A check is a negotiable instrument in the form of a bill of exchange, always drawn on a banker. A check is said to be crossed when two parallel transverse lines, with or without any words inside, are drawn on the face of the check, generally on the left-hand top corner of the check. A check is said to be bounced or dishonored by non-payment when the drawee bank of the check refuses payment upon being duly required to pay the same. Section 138 is about punishment to drawer for the bouncing of a check.
Let us recapitulate what we have learned in this module. A check is a negotiable instrument in the form of a bill of exchange drawn always on a banker. The term banking has been defined as accepting for the purpose of lending or investment of deposits of money from public, repayable on demand or otherwise, and withdrawable by check, draft, an order or otherwise, as stated under section 5 subsection B of the Act. The term banking has been defined as accepting for the purpose of lending or investment of deposits of money from public, repayable on demand or otherwise, and withdrawable by check, draft, an order or otherwise, as stated under section 5 subsection B of the Banking Regulation Act 1949. Checks may be of two types: open or uncrossed checks and crossed checks. A check is said to be crossed when two parallel transverse lines with or without any words inside are drawn on the face of the check, generally on the left hand top corner of the check. A check may be crossed in the following ways: general crossing and special crossing, not negotiable crossing, and account payee or restrictive crossing. A check is said to be bounced or dishonored by non-payment when the drawee banker of the check refuses payment upon being duly required to pay the same. According to section 138 of the Act, under certain circumstances, a drawer of a dishonored check shall be deemed to have committed an offence and shall, without prejudice to any other provisions of the Negotiable Instruments Act, be punishable as follows: A. Imprisonment for a term which may extend to 2 years, or B. A fine which may extend to twice the amount of the check, or C. both of these.